The Society broadly welcomes the Criminal Justice Bill. We're very pleased to see the safeguards for vulnerable suspects, for child suspects, and also the reduction in the time limit on detention following arrest. We are concerned about some aspects of the bill, including, for example, the move from a detention-based system to an arrest-based system for questioning. But these are matters we can feed into the parliamentary process as that goes on. The main area where we are concerned is the removal of corroboration. Corroboration has been the main safeguard against wrongful conviction in Scotland for many, many years. And as a result of that, we don't have some of the safeguards which other systems have against miscarriages of justice. And we're very worried that removing the requirement of corroboration without adequate changes elsewhere is going to significantly increase the risk of miscarriages of justice in the Scottish system. There's been some suggestion that the corroboration requirement is unjust, particularly in cases such as sexual assault or domestic violence, which may come down largely to one person's word against another's. Now actually Scotland over time has developed ways of dealing with these types of cases and allowing other evidence to be brought in to support the account of the complainant in the criminal case. But if you do have a case that comes down genuinely to one person's word against another's with absolutely nothing else to support the complainer's account of events, it's difficult to see how conviction is ever going to be safe. Other systems that don't have a corroboration requirement have developed other safeguards over time against wrongful conviction, such as strict rules on the use of eyewitness evidence, a power of the judge to take a case away from the jury if it's based on wholly unreliable evidence, or a requirement that the jury verdict be unanimous or at least returned by a very high majority. We've never developed these rules in Scotland, and the argument has always been that we have corroboration, so we don't need them. Now, the only change the government is proposing here is a very slight increase in what is required for a jury verdict of guilty, and that simply isn't adequate, and it would leave us ultimately with one of the lowest levels of protection against wrongful conviction in the Western world. There's a problem with the evidence or the lack of evidence that's been used to justify this change. Now, we're often told that corroboration is very unusual. No other system has a general requirement of corroboration in criminal cases. And that's true. But if we simply abolish corroboration from the Scottish system, we'd then be left with a system which, for example, would allow conviction by a jury that's not required to give reasons or a bare two-thirds majority on uncorroborated evidence. Now, you can't say that we know that system is safe because that system doesn't exist anywhere else. It's not been tried.